are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7103. Pablo Abreu, appellant versus Howard University. Mr. Carlin for the appellant, Mr. Previs for the appellee.
Good morning, Mr. Carlin, you may proceed, and I'll just let the parties know in the second case that we'll take a 10-minute break after this argument before we proceed with the arguments in the second case.
Good morning, Your Honors. May it please the court. My name is Stuart Carlin, and I'm representing Pablo Abreu, the appellant in this case, for purpose of the oral argument. Only he is pro se. The underlying case, he's pro se, or I did give him some assistance drafting the brief. Closed in brief in chief.
The complaint was drafted by an attorney.
Yes. Yes, Your Honor. It was drafted. He had representation below in the district.
Yes. All right. You can proceed.
Okay. So in this particular case, the first and prominent issue, I think, is the statute of limitations. What statute of limitations applies both to the ADA 504 claim. Now, my very skilled adversary raised the issue of waiver, so I wanted to put that head on because the statute of limitations was 1 year, was held that it was 1 year. And so these issues with respect to the 3-year statute, 4-year statute, 1 year plus the tolling was not presented below. But I would respectfully submit that when you deal with the issue of statute of limitations, courts have the discretion to overlook that waiver argument. And the test has been, does it below where the parties fairly put on notice as to the substance of the issue. And here, the only issue was the statute of limitations. So it is respectfully submitted that the court, in its discretion, should look at the statute of limitations because of the importance of it, because the issue was dealt head on, and all the parties were put on notice as to the substance of the issue. Now, with respect to the statute of limitations on the ADA and 504,
was the district court? I guess the district court wasn't apprised of the Stafford decision below because it was after the district court's decision.
That's correct.
All right.
So the
why doesn't Stafford resolve the limitations issue, at least on the Rehab Act?
Well, Your Honor, I believe that there needs to be a uniform statute of limitations that applies in basically civil rights cases. The three-year statute of limitations seems to be the overwhelming. Circuits have adopted a personal injury statute of limitations, which in this instance would be the 3-year statute of limitations. And I believe that the uniformity is really critical here. Under Title VI, under 1983, there's a 3-year statute of limitations. Hard to distinguish between why that should be different in an ADA or even a 504 setting. The issues raised by Appley is that, well, the ADA 504 doesn't deal with the issue of intent, but I respectfully submit that it can deal with the issue of intent. And you would have cases where on an accommodation issue, first there could be an intent issue on that in any event, as well as under the ADA 504. Obviously, if someone's not hired because the person has, let's say, bipolar, which is a disability, and it was known, it was deliberate, then you would have a 3-year statute of limitations applying to part of the act and a 1-year statute. It's not really a workable solution. It seems to me that uniformity in this particular instance is really critical. There should be clear voice from the court as to what the statute of limitations is, and that clear voice would be consistent with the Title VI and 1983 Civil Rights statutes. In the event that the 3-year statute doesn't apply, there's also respectfully submitted that the default statute, when there's no statute that applies, there is a default statute that was enacted in 1990, and that is a 4-year statute of limitation. So the argument is that anything that came before, you would not apply the default statute. However, the Supreme Court was clear that if the ADA was amended after and gave a cause of action that didn't previously exist, that then the 4-year default statute would apply. The old law before Congress enacted the amendments to broaden the definition of disability was if it was seriously restricted from activities of central importance to most people in their daily lives, it has to be permanent and long term. In this particular instance, it's respectfully submitted that episodic and something that is that has and the other thing is if it had mitigating measures, it also wasn't it didn't apply. In this particular instance, I don't believe Mr. Abreu would have had a claim.
Let me interrupt. Even if you are correct that it's a 3-year statute of limitations, and so the claim was timely, there's been an alternative argument that the case should be, the dismissal should be affirmed because your client failed to state a claim. In 2 respects. One, that it was not pled that Mr. Abreu was a qualified individual with a disability, in the sense that I don't see in the complaint where the complaint says, if I had this accommodation, I could take this exam the 4th time and pass it. And absent that, how is there a plausible claim that he's a qualified individual?
Well, it was enunciated in the complaint that that he was requesting a reasonable accommodation, not just to take it more than 3 times, which was the standard in the boards itself. It was 6 at the time. It's been reduced since then to 4. But in addition, he was asking for extra time when he took the test. He needed the extra time for several reasons. Most importantly, it took time for his medication to basically work, and it was being adjusted. And this was not just for the 3rd test, the 2nd test when the delay occurred. So we're at the motion to dismiss stage where plausibility, whether or not it's plausible, when one construes all facts in plaintiff's favor as to whether or not just the 3rd test, but whether or not they violated the ADA in the 2nd test when they were put on notice and he was asking.
But the complaint doesn't say, I want to take it a 4th time, and the 4th time, instead of having 3 hours, I want 4 hours. And if I get those 2 things, I can pass the test. I mean, there's just nothing spelled out to show, I guess, that it's going to be anything other than just a futile effort to allow him to take it the 4th time. You see what I'm saying?
Yes, Your Honor. It would be somewhat speculative whether or not he would pass it or not the 4th time, but the point I'm trying to make, Your Honor, is that in the 2nd and 3rd test, he was asking for extra test time because of his condition, period. And that was denied, period. He never got the extra test time. On the 3rd test, he didn't even get notice of the exam. They had until the middle of July to schedule the exam. They could have given him extra time. There was it wouldn't have
But I don't
impacted.
read his complaint as saying that my claim is that the accommodations that I already received weren't good enough because I should have been given more time on the second test and I didn't get that.
I think it could be reasonably inferred. The other thing, Your Honor, is the ADA and the Bible Forum in the last decision, the merits of that claim were not reached by the court below. The only thing that was before Your Honor.
I understand, but we can affirm on alternative grounds.
I understand, Your Honor. I think a fair reading of the complaint is that he was forced, one could reasonably infer, drawing all reasonable inferences in favor of the appellant, that his denial of the extension of time to take the exam when he was been diagnosed with severe anxiety and ADHD, one could reasonably infer, but for not getting the extension, that he would have passed. That's the crux of the complaint.
The other argument that's made for failure to state a claim is that it would fundamentally alter the educational program to allow him to take it a fourth time. And there's several cases that are cited. And most of those cases were decided on summary judgment. But when I read them, I don't really understand that there would really be discovery or evidence that they're relying upon to make that ruling. The courts are saying just the nature of professional schools are such that they have standards, the kind of reputation of the school is at stake. The safety of the community is at stake with, nursing and medical and other licensing requirements. And so it just kind of goes without saying that it would fundamentally alter the program to allow someone to not have to pass a certain course or to take an exam, an additional time. Why isn't that a suitable alternative grounds for affirming?
Because it's a summary judgment issue, Your Honor. And the reason why it's a summary judgment issue is that, Mr. Abreu, through expert testimony, through the fact that the board itself at the time allowed candidates up to 6 times, and other, even though it's been reduced now to 4 times. Well, that type of discovery was not available because this was dismissed at the pleading stage. There's no record as to that at this particular point in time. There could be many other schools that allow more than 3 times. The accreditation may allow more than 3 times. They may make the policy that is 3 times, but it's respectfully submitted at a motion to dismiss stage at the earliest possible stage that the plaintiff is entitled to develop the record below and present the arguments that it would not impact the integrity academically of the program, especially in light of his disability.
Thank you. Judge Rogers, did you have any questions?
No, the only question I wondered about was the policy. If counsel can advise us, how is the policy developed? Is this something out of the president's office? Is it the board of trustees? Is it operating board?
Your Honor, I don't know the answer to that question. We haven't had the benefit of the discovery. So the policy.
That's a matter of public record, one way or the other, isn't it?
Yes, Your Honor, but I don't know the answer to that question. Sorry to say.
All right. We'll give you a couple minutes.
Thank you.
May it please the court, Daniel Previs for appellee.
Good morning, counsel.
I'd like to address the issues that Judge Wilkins was addressing in terms of whether the case should be affirmed on the alternative grounds that there was no, that there would be a fundamental alteration of the university standards, and also that plaintiff has not pled that he would be qualified and able to pass the exam with a fourth attempt. I want to just factually make a couple things clear here. The US MLE test is administered by the National Board of Medical Examiners. So if you want 3 hours instead of 2 hours, that's the entity you go to. If you want more opportunities to take the test, then you can ask the Howard University College of Medicine. And the Howard University College of Medicine is the one that developed these policies based on its assessment of what is suitable for its academic program. I mean, at bottom, what this case is about is a regrettable situation where a student is unable to pass a licensing exam after 2 years of study and 3 attempts. And the university has an obligation to make sure that those people going through its program are academically qualified.
I understand that. I guess to get to the nub of the issue, how is that suitable, the fundamental alteration issue, how is that suitable for resolution on a motion to dismiss rather than a motion for summary judgment? I don't see any Court of Appeals cases that have resolved that on the motion to dismiss. They all seem to resolve it on a motion for summary judgment.
Well, Cunningham was resolved on a motion to dismiss, and Lipton, which was affirmed by the Second Circuit, was decided on a motion to dismiss. And furthermore, the other cases that had addressed the issue have addressed it as a matter of law. As a matter of law, it's now firmly established by all these decisions that seeking an extension, more opportunities to take the licensing examination is a fundamental alteration of the program.
Has Howard University over the years, though, changed the number of opportunities that, the number of times you can take either the step 1 or step 2 exam?
I just don't know the entire history of what Howard has done for the last 100 years of its College of Medicine, but this policy has been in place since 2015 at least. And this is not a unique policy to Howard University, as
I know you may not know
indicate.
100 years, but do you know whether in the last 20 years it's been different?
I don't know the answer to that. I'd like to give you an answer that it hasn't been changed, but I can't represent it. But what I do know is that it appears to be a firmly established rule of law that this is a fundamental alteration. And we haven't heard from.
Do all medical schools cap it at 3 opportunities, the step 1 exam?
Well, first of all,
some give more opportunities.
It's up to each academic institution to determine what's appropriate for that institution. And Howard, and if you read these cases that were cited, what you see there is the courts say, look, we're going to give deference to individual academic institutions to determine what is the appropriate number of times and period of time to pass this examination. And that may, there may be differences of opinion among different medical schools, but Howard has chosen these rules. They're reasonable rules. I mean, 3 times to take an exam, 2 years to pass an exam. When you go see a doctor, you don't want to know that they get the answer wrong the first 3 times, or it takes them 2 years to get to the right answer. That's what these policies and rules are all about. They're about this institution's fundamental academic judgment about what its educational policies are, and that's owed a great deal of deference. And I can't imagine anything that would be produced by remanding this for discovery that would affect that discretion. And counsel hasn't suggested any such facts to you. There are no such facts that have been pointed out in the briefings of this case, either in the lower court or in this court. So I think this court ought to be able to comfortably rule as a matter of law that there's a fundamental alteration being sought here. It's inappropriate. And in addition, there's no real allegation that Mr. Abreu would have been able to pass an exam a fourth time around. There's no evidence or allegation that he has done something different that would enable him to improve on the outcome after 3 tries.
Let's suppose you had a case where the student had a seizure during the first 2 times that they took the exam, and that impacted their ability to pass the exam. And then they were diagnosed with epilepsy, and they took some medication and took it the 3rd time but didn't pass. And then they said, well, I think now that, if I get one more chance, because the first 2 chances that I got weren't really, adequate because I had a seizure in the middle of those 2 exams, I want a 4th one.
Okay.
Would that raise a question of fact as to whether or not they should get a 4th try as a reasonable accommodation, or as a matter of law, we would say, no, that would fundamentally alter Howard's academic standards in a way that it's not reasonable?
It could alter the evaluation, but that's not what we have here. Remember here,
But would it be a fundamental alteration where that argument would be just dismissed out of the box?
No, it wouldn't be a fundamental alteration because the candidate wasn't actually able to complete the exam due to a medical reason. I mean, Howard University is a reasonable institution, and it was those facts don't fit here because
doesn't that undermine the contention that just as a matter of law, asking a university to grant an additional exam is a fundamental alteration and can't be expected under the Rehab Act or the ADA?
Yes, it affects it under those assumed facts, but the facts here, I haven't been able to get this out.
Well, if you win as a matter of law, then the facts don't matter, right?
Well, as a matter of law, in circumstances like those here where the university accommodated him, it gave him leaves of absence, it gave him additional time. It did a lot for him. It didn't, the university is not out there to get students and throw them out. The university wants these students to succeed, but it also has a responsibility to produce qualified people. And in this case, the university accommodated Mr. Abreu in several ways. And there was no mid-exam breakdown. He didn't have a heart attack.
I understand your argument. Maybe in the time that you have, you should address Stafford and the statute of limitations.
Just one quick question before you get to limitations. I thought fundamental alteration was a defense, no?
Well, as a matter of law, it is, I think it is a defense.
Okay, then.
But it's an element of the cause of action. The statute says that you're not entitled to
I thought it said something like, unless the employer or institution or whoever proves that this would.
It doesn't say unless the institution proves. It says unless it would be a fundamental alteration. So it's part of the plaintiff's cause of action to show that
if it were a defense, we couldn't resolve it on a motion to dismiss, correct?
Sure you could. You can
why not? Why?
You can resolve. I mean, statute of limitations is an affirmative defense. That's resolved all the time on appeal on motions to dismiss
Not
where the
if-
facts are
Not
clear.
if the defendant doesn't raise the defense.
Well, the university raised this defense in its motion to dismiss. This was a defense that it raised. So it was addressed, it raised it. The lower court found it unnecessary to reach the issue because it decided the case on the grounds of statute of limitations. But the arguments were made, and the Court of Appeals and a lower court are entitled to grant summary judgment as a matter of law on an affirmative defense.
Without an answer.
Well, a motion to dismiss serves the purpose of an answer situation. Okay, so with respect to Stafford, Stafford is a different statute, and it has had a different logic to it. The logic of Stafford is that discrimination, intentional discrimination, is like a personal injury tort. It sounds in tort. And that goes way back. If you look at the Wilson versus Garcia case, and you look at that, the court was talking there about a Civil War era statute. It was talking about intentional discrimination. It was talking about all kinds of atrocities, lynching, whipping, those sorts of things. And it was quite natural for an intentional discrimination claim to be viewed in some respect as sounding in tort, because that's what happens. That's not true in a reasonable accommodation case or in an ADA case generally, where there can be liability without discriminatory intent. So the statutes and the logic are completely different. One of the concerns in Stafford was that all the other circuits had ruled that the personal injury statute applies. That's not the case here. I mean, we know the Fourth Circuit and the Ninth Circuit follow the state anti-discrimination law statutes of limitations. And we know that several other circuits have indicated that if there was a very close mirror state anti-discrimination statute, that would control. So in this case, if you rule in favor of the 3-year statute of limitations, then you're actually out of sync with most of the other circuits that have addressed the issue. So I think the statutes are very different, and the weight of authority is different.
Stafford, rightly or wrongly, had already held the governing limitations period for Title VI.
For Title VI, which is intentional discrimination.
And the Rehab Act adopts remedies, procedures, and rights of Title VI. So is your argument that a statute of limitations is not a remedy, procedure, or right?
Well, remember, the basic principle is you have to look at the most analogous state statute. Okay? The most analogous state
No, for the Rehab Act, you have to look to Title VI.
Title VI.
Unless the statute of limitations is not a remedy, procedure, or right. Seems like a pretty tough position for you.
Well, Stafford did not address intentional discrimination. And the weight of authority is you go to the state statute. And a failure to accommodate is not like intentional discrimination. You're not doing something affirmatively to somebody else. You're trying to, you're trying to ameliorate a pre-existing condition or circumstance. So the whole logic of this kind of claim is inconsistent with Stafford and its rule. And I don't see anything in Title VI that has a remedy for failure to accommodate. So there's no remedy under Title VI for failure to accommodate. There is a remedy under the ADA. And let's not forget that the DCHRA has been construed by this court as being really identical in practice the DCHRA is not very as elaborate as the ADA is or the Rehab Act is, but the courts have ruled that we're going to import all of that law into the DCHRA. So how could that not be the most analogous statute of limitations?
All right, Judge Rogers, did you have any questions?
No, thank you.
All right, thank you, counsel.
Thank you.
All right, we'll give you, Mr. Carlin, 2 minutes for rebuttal.
I just want to touch on the scenario that Your Honor presented, and there was candidly an admission by my adversary when you posed a question about someone who had epilepsy. Well, my client was sick too. He had anxiety, which placed him in the 98th percentile. He was basically an emotional wreck when he was taking those exams. I would respectfully submit that there's nothing distinguishing in terms of the logic that would apply to my client that would apply to someone who has epilepsy, and when the school would consider a fourth exam. Period, stop. I mean, there's just no difference. And I would respectfully submit that in this particular instance, besides him asking for extra time to him, which would have allowed him to adjust his medications, lowered his anxiety level, that was denied. Besides that,
but extra time, there's no pleading in the, there's no allegation in the complaint that Howard had the purview to give him extra time on the exam.
I believe it's set forth in paragraph 36 and 37 where extensions were requested by an attorney in the amended complaint.
All right. Anything else?
No.
All right. We'll take the case under advisement. We're going to take a 10-minute recess for the benefit of our ASL interpreter, and then we will hear the parties in the next case.
Thank you, Your Honor.
The sound came and went during oral argument, so I'm going to telephone in for the next argument. Sure.
Meeting ID followed by pound. Enter your participant ID followed by pound. Otherwise, just press pound to continue. Please enter the meeting passcode followed by pound. You are in the meeting now. There are 12 participants in the meeting. This meeting is being recorded. You
Stand, please. This honorable court is again in session. Be seated, please. Case number 22-1214 et al. Food and Water Watch petitioner versus Federal Energy Regulatory Commission. Ms. Doran for the petitioner, Mr. Ediger for the respondents, Mr. O'Neill for the respondent interveners.
Good morning, Ms. Doran. We will hear from you.
Good morning. May it please the court, Erin Doran on behalf of petitioner Food and Water Watch. I've reserved 2 minutes for rebuttal. We're here today because the Federal Energy Regulatory Commission approved the East 300 project despite New York State's groundbreaking climate law and without adequate review of environmental and climate impacts. Today, I'll talk about 3 ways in which the Commission erred. First, the Commission failed in its consideration of all factors related to the public interest and need for the project, and specifically failed to give adequate weight to New York's Climate Leadership and Community Protection Act. Second, the Commission failed to assess and determine the significance of the project's impacts on climate change. And third, the Commission failed to adequately evaluate and disclose the project's indirect and climate impacts. For these reasons, Food and Water Watch respectfully requests that the court vacate and remand the orders under review. Turning first to the Commission's failure to consider the New York Climate Leadership and Community Protection Act adequately in its need determination. The Commission here based its finding on a single precedent agreement. And while precedent agreements are important factors under this court's precedent, the court has also recognized in Environmental Defense Fund that they're not always determinative. FERC's 1999 policy statement reflects its obligation to consider all relevant factors. And in 2022, the Commission recognized that it is short, over-relying on precedent agreements. There, the Commission identified the precise problem here, that if the Commission relies on precedent agreements at the expense of other contrary factors, it reaches a determination on need that's inconsistent with the weight of the evidence. Here, FERC seems unable to even grasp the relevance of the Climate Act in this proceeding. To be clear, the Climate Act is relevant because of its long-term implications. New York is moving away from fossil fuel use, and that will implicate demand.
Moving away, but Con Ed signed a 20-year contract.
Yes, Your Honor, Con Ed did enter into the contract here.
In the face of shortages in Westchester County.
Correct. Con Ed may have been motivated by short-term constraints to enter into the precedent agreement, but the precedent agreement nevertheless is for a 20-year term, and the life of the infrastructure itself will extend beyond that. And that's inconsistent with what will happen over the course of the Climate Act's implementation, with New York seeking to reduce by 40% by 2030 its greenhouse gas emissions. That's just
But
7.
Certificate of public need and necessity. People need gas now. Con Ed thinks that's a serious enough problem to commit themselves for 20 years. So sure, the project might last 30 or 40 or 50, but that doesn't bar them from issuing the certificate.
Well, Your Honor, respectfully, we're arguing that the Climate Leadership and Community Protection Act should have been given adequate weight in light of its implications on long-term demand. So again, while Con Ed may have been motivated to enter into the precedent agreement based on short-term constraints, it has other options, and it has dealt with these issues for the past several years, using solutions that are more consistent with the Climate Act.
Is your argument that they didn't consider the New York Act at all, or they didn't adequately consider it? Because they did
Your Honor,
discuss it, right?
they did discuss the Climate Act to a limited extent. They did not take into consideration the long-term implications on demand. The Commission dismissed the Climate Act because it doesn't ban Con Ed from providing gas right now. But respectfully, the Commission can't see the forest for the trees here. It is ignoring the monumental shift that's occurring in states like New York that have real climate action on the books to accelerate the transition away from fossil fuels. rather than give the Climate Act the weight it deserved, the Commission simply approved this based on the precedent agreement.
Well, but isn't it true that the commission focused on concerns it had about the short-term measures that were being used and had been used for the last few years, trucking, moratoria, et cetera. So it's not as though it didn't take into account other concerns that were contrary to policies it thought were important. Isn't that correct? I mean, the record demonstrates that.
Your Honor, the record does include assertions by Con Ed about need. It also includes internal snapshots from Con Ed suggesting that need had increased at least 2013. Those projections themselves are inconsistent in the record, and FERC's ultimate determination on need here was based on the precedent agreement. Again, not taking into account what will happen with need over the longer term.
I understand your point, but I'm trying to focus on the now aspect, following up on Judge Katsas' question. I didn't see, and maybe I missed, an attack on Con Ed's statements about the situation that it was facing in terms of increased demand and the alternatives it had had to use as sort of fail-safe measures during this period, even assuming New York were to get to the goal that you're talking about.
Your Honor, there's no indication in the record, I agree, that there's an attack on Con Ed for the short-term constraints that it's using. We're simply putting forward that the Climate Act needs to be taken into consideration when looking at whether those short-term constraints and other short-term solutions would be adequate, as opposed to locking in carbon and fossil fuel infrastructure for the next several decades. So again, rather than giving the Climate Act the weight it deserves in terms of projecting demand over the next several years, the Commission simply approved the project based on the precedent agreement.
I didn't see.
Respectfully, Your Honor, I'm not sure your question is coming through.
Judge Rogers, we're having problems with the audio. If you could just repeat your question, please. Let's just pause the time if we can. Judge Rogers, I'm sorry, we had problems with your audio. If you could repeat your last question.
Yes, I'm sorry. I've had repeated problems this morning with the audio. It's just not working. I'm on my iPad because my computer won't hook up. So I apologize, but I don't want to delay this. Judge Katsas' question, I think, really covered what I was getting at, and I was just trying to say to counsel, the way I read the record here, and she may have read more of the record than I, there were realities that the Commission was trying to address now.
Yes, Your Honor. The issue with that is over the long term, and again, looking at demand with the implementation of the Climate Act, those factors themselves shouldn't outweigh the movement toward lower demand, the economy-wide implications of the Climate Act. Turning, if I may, to FERC's failure to consider the significance of climate impacts of the project. The significance determination goes to the very core of NEPA. Here, Chairman Glick said that the significance determination is perhaps the single most important step in informing federal decision makers and the public of a decision. And here, the significance determination should have been an easy call, especially when you consider that there will be 2.2 million tons per year of carbon dioxide equivalent, even under the Commission's flawed analysis, as compared to the Commission's initial threshold proposed for significance of 100,000.
I'm trying to understand this argument. The statute requires a significance finding with respect to whether to do an environmental impact statement or not. Where else does the statute require a significance finding?
Yes, Your Honor. So significance is relevant in getting from an environmental assessment to an environmental impact statement. However, NEPA is not an exercise in busy work. The significance determination should actually influence the Commission's decisions. And in making that determination, the Commission should communicate to the public about how it is taking accountability for the climate impacts of the projects it approves.
But we've never said, and I don't believe you cited any other court opinions that have said that a significance finding is necessary in some context other than whether or not to do the environmental impact statement. Am I right about that? There's no precedent that says that if you've done the environmental impact statement, you still nonetheless have to make a significance finding?
Your Honor, there may not be precedent on that specific point, but I would direct the court to EPA's conclusions here, where EPA found the final environmental impact statement contained insufficient information to assess potentially significant environmental impacts of the proposed action and is inadequate to meet the purposes of the National Environmental Policy Act. So beyond that procedural component, NEPA requires agencies to take that hard look and to make a determination as to whether their projects will have significant environmental.
I get that. I mean, that's the core of NEPA, that the agency has to really consider all the relevant factors and take the hard look. But that's different than saying that you know, even if it considers all of the factors, it's still deficient because they didn't say, you know, which factor was significant or not significant. That's what I'm trying to get to. It's like, what does it really get you for us to find that there was a significance finding that should have been made that wasn't?
Your Honor, again, I would suggest that this is not simply a procedural issue, but a substantive issue under NEPA, that the Commission failed to grapple with whether climate impacts are significant. This project could have had 100 times the impacts that the Commission says it will have, and they would still defer on significance, failing to take accountability for those actual climate impacts that they know, as Chairman Glick said, they know will occur. Simply claiming there's no universal standard, simply trying to avoid conducting this analysis and making this determination based on an ongoing generic proceeding. But the Commission has to comply with NEPA now. We can't come back.
The Commission calculated the social cost of carbon. The Commission calculated the amount of greenhouse gas emissions. The Commission did lots of different things. What the Commission said is that ultimately, we don't believe that there is kind of one reliable methodology to determine kind of climate impact, but all of the various different types of methodologies were used by the Commission. They just said that we can't find one that we find is reliable. Is that a fair assessment of the record?
The Commission does claim, yes, that they don't have that universal methodology, but as Chairman Glick said, again, a universal methodology is not the standard here. In saying we can't figure out significance, the Commission is refusing to really grapple with the impacts that the project has, the impacts that its approvals are having, waiting for this generic proceeding.
So I'm just trying to understand, was there a calculation or methodology that the Commission should have used that it did not use?
Well, Your Honor, there were several methodologies that the commission should have used. And to the extent it did use methodologies like the social cost of carbon, the commission went only so far and then decided not to say whether that impact is significant.
Is there a methodology that they should have used that you asked them to use that they did not use?
No, Your Honor, we don't have a specific methodology that FERC needs to use. There are numerous methodologies that the commission could consider. The commission could also go back to what it did in the Northern Natural Gas proceeding.
But the problem here is that if you fail to ask them to use a specific methodology, you can't come here now and say, well, they should have used that methodology.
Well, respectfully, Your Honor, we did identify the social cost of carbon, but that is not, a methodology that is the only one that the commission could use.
And they calculated the social cost of carbon, right?
They did, and yet they didn't say whether that was significant. And it's important to note that agencies make these determinations.
So we're supposed to overrule their scientific judgment about kind of how reliable that methodology is for this purpose.
No, Your Honor. What we're asking the court to do here is recognize that the commission failed to consider the important aspect of the project here, which is the significance of the impacts on climate change. It didn't come to a conclusion, and it's going on approving projects without identifying and taking responsibility for whether those projects are having a significant impact on climate. And agencies make these determinations all the time for things outside of climate. They consider any number of environmental factors that have multiple methodologies and use their judgment and experience to get to a determination about the significance of those impacts, which again should inform the contours of the project. I see that I'm out of time.
I'll give you a couple minutes to make any final points or to cover something that you did not get a chance to.
Thank you, Your Honor. First, I will say that with regard to upstream impacts, they are reasonably foreseeable, and we know that because EPA told the commission that fact in the record. Second, downstream impacts are also reasonably foreseeable because the commission knew exactly where the gas was going and exactly how it would be used. And for these reasons, again, Food and Water Watch respectfully requests that the court vacate and remand the orders.
So on the upstream, where the commission found that we really didn't know where the gas would be coming from because of all of the different lines that could input into the pipeline. If that finding is correct, kind of given our precedent in Burkhead and Sabal Trail and others, doesn't that relieve FERC of the obligation of calculating greenhouse gas emissions, et cetera, associated with upstream effects?
Respectfully, Your Honor, if that finding is correct and Food and Water Watch doesn't believe it is, in this case, Food and Water Watch did raise in its rehearing request the commission's responsibility to ask for additional information. So the court doesn't have to reach the same conclusion and take the record as it stands as it did in those previous cases. However, I will say again that EPA told the commission they could use default assumptions here to evaluate reasonably foreseeable upstream impacts. These impacts are global. The commission knows it. It doesn't depend on where they occur, and omitting these impacts resulted in a lack of informed decision making.
All right, Judge Rogers, did
Thank
you have
you.
any other questions?
No, thank you.
Thank you.
All right, thank you. We'll give you a couple minutes on rebuttal. Morning.
Good morning. Good morning, and may it please the court. I'm Scott Ediger. I'm for the Federal Energy Regulatory Commission, and thank you for hearing this case this morning. I would like to take the issues in the same order addressed by Food and Water Watch, and I'd like to make a few comments about the need determination. And I want to emphasize First, I want to discuss the Environmental Defense Fund case cited by my friend for Food and Water Watch. That case is distinguishable from this one in that a single precedent agreement was at issue there with an affiliate. And it is clear from that case that the court there was concerned in light of those two facts and the fact that there wasn't additional evidence of a growing need in the service area, that the commission hadn't taken seriously issues of self-dealing. That is the opposite of the situation that we have in this case today. Consolidated Edison is not an affiliate of the pipeline. This is an arm's length transaction, and this transaction itself, as this court has said in Delaware Riverkeeper, Adelphia, citing Minisink and Myersville, that contract itself is important evidence of need. And as we pointed out in our brief, the need didn't stop there. The commission went well beyond that, and as the colloquy that the court has already had with petitioner, there are additional facts that play in here, and that is that Consolidated Edison participated in this proceeding and explained that they have had an increased load growth, and as a result, they have had to resort to extraordinary measures such as trucking compressed natural gas and imposing a moratoria on new hookups. So the contract is not just a simple contract. There's a lot that goes behind the contract, and that we have significant evidence of need here. I would also point out that, and I'm going to make a negative inference here, that the New York Commission is not here today saying that the Commission erred by granting a certificate. That does happen in other cases, and I can cite one, and I don't cite this for precedent, but this is just an example. For example, an order in the Spire case, which this court reviewed in Environmental Defense Fund, if we look at 164 FERC 61085, paragraph 30, the state commission there was in front of the commission saying that the commission should not approve the project or should not validate the precedent. That is not the case here. And I just cite that not as precedent, but just as an example and making an argument of negative inference that the New York Commission isn't here today saying, no. Don't look at this contract. And the New York Commission, as we pointed out in our brief, is the entity that regulates Consolidated Edison.
I don't want to get you off track too much, but I did want to ask you questions about upstream effects, and particularly, even if we take the commission at its word, or not at its word, we say it was a reasonable conclusion for the commission to make that we don't know exactly where this gas is coming from. It may not all be coming from the Marcellus shale. The EPA says that doesn't matter because greenhouse gas and other impacts aren't localized. But the commission said, well, we're not going to calculate those because they're not foreseeable because we don't know where the gas is coming from. How are we supposed to reconcile kind of those two conflicting judgments of expert agencies, so to speak, and isn't EPA a little bit more of an expert on this issue than FERC, respectfully?
The EPA does certainly have expertise, but we are here to review the commission's orders under the relevant standard of review, arbitrary and capricious, and the commission has expertise here and is entitled to deference on this question. And I would submit that the commission was on firm ground when it made the determination that we're talking about, i.e. the gas that will be transported by this project can come from a vast swath of geographic location from the Rockies going down to the Gulf Coast. And the commission said that in rehearing order, paragraph 27 at JA 435. The commission also cited a order that was over 10 years old, a Tennessee gas case 131 FERC 61140 at paragraph 18, which made the same point, that the project will allow shippers to have access to vast supply sources. And the commission also cited the application that Tennessee filed in that docket, that CP 09444, that was filed on July 17th, 2009. And the commission also cited the exhibit to the application Z4 at page 2 and the footnote 4 to that exhibit. That's at JA 33. Commission discussed all this in a footnote to the rehearing order, footnote 74, that's attached to paragraph 27, JA 436. So that's a long-winded way, Judge Wilkins, of answering your question, that the commission here was on solid footing in making the conclusion that the supply sources for this project can come from a vast variety of geographic locations. And based on that, the commission couldn't tell what the environmental impacts were. And if I could add just one more thing, I would point.
Well, I guess let me just try to see if I can simplify my question. Let's suppose that it were undisputed that it were all coming from the Marcellus Shale region. Then you would agree then that the commission would have had an obligation to look at these kind of indirect upstream effects with respect to that region, right?
I'm not sure I would concede that, Your Honor, and I would point Your Honor to Burkhead on that point, where the shipper was a producer. That's an important distinction here. The shipper here is the opposite of that, is an LDC, and they're going to
understand. I don't want you to fight my hypothetical. I want you to try to answer my hypothetical. Let's suppose we knew for a fact that all of the gas was coming from a particular region. So wouldn't the commission under those circumstances have an obligation to, for instance, calculate the additional greenhouse gas emissions or other emissions as a result of that increased supply?
I don't think that's necessarily true. I think the commission, and I would point you, Your Honor, to the final environmental impact statement at page 28, JA 258. And there, commission staff talks about all the things that are unknown here. And that's the location of the supply source and whether there would be new or existing wells that would be necessary. And under Your Honor's hypothetical, if somehow we knew that the gas would come from a particular region, and again, I believe the purpose of mentioning Burkhead is, I think, given that the shipper there was a producer, that you had perhaps that regional aspect to it. I think it's still unclear, or it would be in this case, unclear whether the supply is coming from new or existing wells. And we don't know that. And we don't know where the location of those wells would be. And what the commission staff there explained was that the commission approaches this on a case-by-case basis. And if there are new infrastructures involved, that's a whole new, you would think that would be a whole new different set of environmental impacts, because there might be affiliated infrastructure, et cetera.
And when the EPA made its comments about upstream greenhouse gases, in its comments that are at J196, and they said that there were these various generic estimates that could be used from the Department of Energy methodologies. You're just saying that the EPA just has that wrong there because those estimates don't really work if we don't know whether there's going to be new wells or not?
The result, and let me quickly explain that the The commission did acknowledge EPA's comments at the certificate order, paragraph 55, JA 352. The commission was well aware of EPA's comments and took it seriously. I think what the commission is saying here is that despite EPA's comments, is that this production would not be causally connected, and that's because, and as the commission explained, the source is unknown and can actually change. So that undercuts the idea that that there's actually a causal relationship between this project and what may have happened in terms of upstream production.
All right, thank you.
And if there are no additional questions on that, I might turn to significance of the greenhouse gas emissions. And Judge Wilkins, I want to go back to some of your questions about that. And I think you're right that we start with the basics. We start with the statute itself, 42 USC 4332, which says that the agency, if there's a project that's going to significantly affect the environment, then it has to do a report. And then, as we cited in our brief, 40 CFR 1502.16, which says not that the commission or an agency has to do make a significance determination, but that it should study the significance of those impacts. And I would assert, I can go through all the information that's in the record here. The commission has definitely studied the significance of greenhouse gas emissions by disclosing the quantities of greenhouse emissions, by discussing how those quantities fit in with national and state emissions, by doing the qualitative analysis, and by discussing how those emissions comport with state goals, climate goals. The only other thing, I see I'm out of time. I'm gonna make one more point.
You can make a couple final points.
I want to highlight the fact that, and this is at the certificate order, paragraph 84, JA 367. The commission there finds that this project is environmentally acceptable. And I just want to make sure that it's very clear that all commissioners, although there are concurring opinions in this, no commissioner dissented from that point. This is an environmentally acceptable project, and in light of the significant evidence of need in this case, all commissioners felt like this project should go forward.
Judge Rogers, did you have any other questions?
No, thank you.
All right, thank you.
Thank you.
We'll hear from counsel for respondent intervener.
May it please the court, my name is Brian O'Neill on behalf of the respondent interveners, Tennessee Gas Pipeline Company and Con Ed. I'd like to address a couple of points here. First of all, with respect to need, I think there's just no question in that regard. It's correct that there is a contract, long-term contract between Con Ed and Tennessee. They're unaffiliated entities. This court has found that long-term contract is sufficient for a demonstration of need in several cases, including mini-sink. However, in this instance, the commission took the additional step of looking beyond the contract, and the record is unrefuted on it. I refer you to JA 303 and 315, where Con Ed demonstrated, and this is also unrefuted, that it needs this additional capacity in order to provide service to its existing demand that has been growing over the years. It needs it to end reliance on compressed natural gas trucking that it has. The reliability issue is a real one. It affects it during harsh weather when there's significant snow and ice developments, and trucks may or may not be able to navigate. In addition, the need here demonstrates that Con Ed will be able to lift the temporary moratorium that it has had and to allow existing customers to switch from fuel oil and propane to natural gas service. And significantly, it allows Con Ed to meet its statutory obligation to provide service upon request. Finally, it is the evidence demonstrates from Con Ed's perspective that the that this additional service that it's getting, this additional capacity, is consistent with its goals in meeting the New York Climate Act requirements. This is unrefuted evidence. With respect to significance, we agree with Your Honor that the significant, from the standpoint of the statute, it's required if there is a significance determination. What has to happen is then, not an EA, but an environmental impact statement has to occur. In this case, there was an environmental assessment, there was a draft environmental impact statement, and a final environmental impact statement. This certainly passed muster through this court's precedent, and I'll refer you, as we did on our brief, to the American Bird Conservatory case. With respect to the upstream issue, the commission was spot on this one. Tennessee Gas Pipeline Company is a long line integrated system. It operates on a bidirectional basis. It's a dynamic system. The inputs and outputs vary from day to day, and that certainly affects where the gas comes from with respect to the needs that Con Ed has to meet. Con Ed, for its part, as most, if not all, local distribution companies obtain their gas via contracts with marketers. The marketers have portfolios of supply that can come from anywhere in the country. On the Tennessee system, by the way, in addition to what the commission cited, they also have sources from Canada. But the marketers also have the ability under the commission's regulations to put together in their own transportation portfolios the contract demand that their customers have, as well as their own contract pipelines. So the bottom line is that the source of the gas can vary from day to day, week to week, month. You have no further questions.
All right, let me just check. Judge Rogers, did you have any questions? Judge Rogers, I don't know if you're on mute. Did you have any questions? Judge Rogers, did you have any questions?
No, thank you.
All right. Your Honor, one final point, if I may. I would like to advise the court that the project is in service. It will be fully in service next week.
All right, thank you. All right, Ms. Doran, we'll give you 3 minutes for rebuttal.
Thank you. 3 points on rebuttal. With regard to upstream impacts, the commission is not on solid footing here. The commission is actually on thin ice. Under the commission's rationale, they would never have to consider upstream impacts if they did not know the exact source of gas, regardless of the project, regardless of the scope of the project. EPA says the commission cannot make an informed decision without these impacts. That's at the record at 300. That goes to the very core of NEPA, and here the commission failed to do it. That's arbitrary and capricious. With regard to significance, the commission claims it does all of these things, but ultimately it throws up its hands and approves the project anyway. The commission refuses to use a particular method. The commission refuses to go back to its ad hoc analysis of significance that it did in Northern Natural Gas, and is simply going forward without taking accountability for climate impacts. Third, with regard to need and the precedent agreement, again, the commission did not consider projections consistent with the Climate Leadership and Community Protection Act. It failed to come to grips with this evidence in the record, instead relying on the precedent agreement. Again, the commission identified the problem that occurs here. When it looks at the precedent agreement, it may not give adequate weight to other factors, including here the Climate Act. Thank you.
On upstream effects, are you saying that, can you, I guess, cite a case either in FERC or decided by our court or another court of appeals that has said that you have to calculate upstream effects where you can't identify the source?
Your Honor, there are cases that identify that upstream impacts can be reasonably foreseeable. Here, I am not aware of a case that says when you can't identify the source, but again, we're looking in the context of greenhouse gas emissions and the global impacts this could have.
I mean, hasn't our precedent said the opposite in that it's not reasonably foreseeable, or either that or it's not, doesn't meet the causation standard if we can't say where the gas is coming from?
There have been cases including FERC, including Food and Water Watch, where discussions of reasonable foreseeability and causation were completed. Here, though, the commission is undoubtedly a cause of the indirect impacts of the projects it approves. It could have chosen to deny this project based on climate impacts had it gone far enough to determine the significance of those impacts. So they are causally connected. And again, I would very much encourage the court to look at EPA as the climate expert agency as to whether they are reasonably foreseeable, even if you cannot pinpoint the exact source of gas over the lifetime of the project.
What's your best case for us to find that it's reasonably foreseeable upstream effect, even if we can't identify the source?
Your Honor, that is an excellent question, and I'm sorry I don't have a case for you on that. But again, looking at the context of these impacts and the global implications, I would encourage the court and encourage the commission to take those factors into account. And again, without considering those factors, according to EPA, we cannot make an informed decision.
Judge Rogers, did you have any question?
No, thank you.
Thank you. We'll take the case under submission.